Welcome to the Alexander Hamilton Institute's 2020 Constitution Day Lecture. I'm Dr. David Frisk, a resident fellow here at the AHI. And our topic for this lecture is the U.S. Constitution and America's red-blue divide. The American Constitution is a focus of extraordinary loyalty, and as such it has played a large role in holding our country together. Americans praise it lavishly for this reason, not only for its merits as a governmental framework. We love the Constitution, that is, partly because so many other Americans say they love it. Yet the document gives rise to the most virulent disagreements. Its occasional lack of clarity on major questions of governmental power and process, and on the extent of our rights, combined with its status as our highest political authority, all make the interpretation of our Constitution in regard to major issues a high-stakes endeavor. Because there are such greatly differing approaches to constitutional interpretation, which happen to result in ideologically differing legal and policy results, nominations to the U.S. Supreme Court and the federal appellate courts are occasions for anxiety and even anger on each side of America's deep conservative-liberal or red-blue divide. At times, the Constitution, as interpreted by our higher federal courts, is pleasing to us, and at other times it is highly frustrating. As a practical matter, constitutional law scholar Louis Michael Seidman wrote several years ago, "In the real world, almost no one changes her opinion about anything important just because of the Constitution. We regularly avoid this distasteful necessity by reading the Constitution so as to support the opinions we already hold. Progressives insist on their reading, while conservatives insist on theirs." There is, of course, also much dignity in the Constitution and the Supreme Court, as Anthony Lewis remarked in Gideon's Trumpet, a book about a major constitutional law case in the 1960s in the time of the liberal court under Chief Justice Earl Warren. In contrast to Congress's way of proceeding, through compromise and the mutual accommodations of competing interests, Lewis stressed that Supreme Court justices are expected to engage in a reasoning process. "The search for principle is the essence of the judicial process," he wrote. "It can never be enough for a court to say, as a legislature properly can, X wins the case because he has more votes behind him." Especially in the Supreme Court, which must find in the vague words of our fundamental law the guideposts for a nation, Lewis continued, "every decision should be supported by reasons that appeal to the intellect and to the ethical sense of Americans. The requirement that a court give reasons for its judgments is a basic safeguard." He also pointed out that the justices have an independence that members of Congress do not have, because the Constitution, of course, guarantees that they will hold their offices as long as they maintain good behavior, which in effect means life tenure. In the same book, however, we see one part of the justification for living constitutionalism, as it's called, the preferred left-of-center or progressive judicial philosophy. "The court's function," Lewis wrote, "is not to reflect mass ideas, but to lead enlightened opinion, to educate. At its best, the court is a great teacher, illuminating issues and then drawing support for further steps from the more sensitive public attitudes it has helped to create." Which does sound like a rather political role, even if a dignified and exalted one. And as the legal scholar Morton Horowitz has written more recently, the Warren Court was the first Supreme Court in American history to champion the legal position of the underdog and the outsider in American society. Let us turn for a moment back to the founding era, represented in the painting behind me, a painting of the Declaration of Independence, Deliberations. In his essay number 11, the Anti-Federalist, known as Brutus, wrote that most of the Constitution's provisions, it was then proposed, not yet adopted, that authorized important powers were, quote, conceived in general and indefinite terms, which are either equivocal, ambiguous, or which require long definitions to unfold the extent of their meaning, end quote. Perhaps more important, Brutus warned that the necessary and proper clause left Congress free, quote, to do everything which in their judgment is best. In addition, he feared a love of power in courts, all the way back in 1787, 1788. Every body of men invested with office, Brutus said, are tenacious of power. They feel interested, that is, self-interested, and hence it has become a kind of maxim to hand down their offices with all its rights and privileges unimpaired to their successors. The same principle will influence them to extend their power and increase their rights. This of itself will operate strongly upon the courts to give such a meaning to the Constitution in all cases where it can possibly be done, as will enlarge the sphere of their own authority. When Alexander Hamilton said in Federalist Paper number 78 that the judicial branch has neither force nor will, but only judgment, it is important to understand what that means. Today, the concept certainly survives, but we also have the concept of courts actually changing the law and constitution, and the concept of judges engaging only in judgment has been criticized as naive, since there's a common assumption, and long has been, that objectivity in the interpretation of the law and the Constitution is impossible. One thing that makes the Supreme Court so controversial is the fact that declaring a law passed by the people's elected representatives, usually on the state or local level, unconstitutional is, so to speak, a trump card, and without question, an undemocratic one. This aspect of our system is sometimes referred to among constitutional law scholars as the counter-majoritarian difficulty, the fact that we have a major undemocratic and therefore counter-majoritarian, non-majoritarian part of our system, and an extremely powerful one. We have seen Horowitz's praise of a Supreme Court that finally sided with outsiders or the historically disadvantaged. But a good statement of conservatives' frustration with the left of center or progressive or living constitution view of constitutional interpretation, which is essentially the view of Professor Horowitz and of Anthony Lewis, the author quoted earlier. The belief that constitutional interpretation should suit the social needs of the times, should make society more equal when possible, and allow more personal, but not usually more economic freedom, comes from the late conservative jurist Robert Bork, who warned in regard to such decisions by the courts. The results are twofold: the erosion of democracy and the movement of the culture in a left-liberal direction. If the text, history, and structure of the Constitution no longer guide and confine the judge, he has nowhere to look but to his own ideas of justice. And these are likely to be formed by the assumptions of the intellectualized elite he has known for most of his life and whose approval he very much wants. And as Bork noted, when the judge's views are claimed, however implausibly, to be based on the Constitution, the legislators and the public are helpless. There's no appeal from a Supreme Court ruling. There are, theoretically, more democratic alternatives to the Supreme Court having, as it does, the final say. Chief Justice John Marshall established this principle of judicial review back in the early 19th century, but there were two alternatives: legislative supremacy and something called coordinate review. Under the legislative supremacy approach, enacted laws could not really be challenged, as in England, where, in scholar Christopher Wolfe's words, the doctrine that the legislature, Parliament, is the ultimate sovereign power and that its acts are unreviewable by any other body became the basis of English law. As the great 18th century legal authority Sir William Blackstone put it, "True it is that what the Parliament doth, no authority upon earth can undo." The other alternative principle, coordinate review, means that each branch is or would be allowed to interpret the Constitution as it wishes in regard to questions that branch legitimately deals with. This was the general view of both Thomas Jefferson and James Madison. As then President Jefferson wrote to Abigail Adams in 1804 in regard to the constitutionality of the Alien and Sedition Acts, "Nothing in the Constitution has given them, the judicial branch, the right to decide for the executive more than to the executive to decide for them." The intent of the Constitution, Jefferson added, was that each of the government's three branches, quote, "should be checks on each other." The view that, quote, "gives to the judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, but for the legislative and executive also in their spheres, would make the judiciary a despotic branch." And a decade later, in 1815, Jefferson wrote similarly in a letter to W.H. Torrance that nothing in the Constitution had given the judiciary any more power to decide on a law's constitutionality than was given to the other branches. Each branch, he believed, should make its own decisions about constitutional questions it was faced with. Jefferson predicted that there would generally be, quote, "accommodation" or compromise between the differing branches due to the prudence, again his word, which he expected from the officials involved, and from demands or expectations of compromise from, again his words, public opinion. Jefferson also thought the legislative supremacy position, however, was a reasonable one. There was a degree of what he called safety in such a method of constitutional interpretation, he said, because the public could always express its views of Congress's judgment in the next election. Jefferson even opposed federal judicial review of decisions by the state courts, believing that a nationwide constitutional convention should be called to consider such situations. But it is far from clear that coordinate review, as I've described Jefferson's rationale for it and description of it, would work well. Judicial review is almost certainly here to stay. But rather than make an argument for the conservatives' favored originalism or original meaning focus in constitutional interpretation, let me suggest in this lecture an understanding of how our government and society are supposed to work under the Constitution. Among conservatives' greatest frustrations in constitutional interpretation has been the modern interpretation of the First Amendment's Establishment Clause, which states that Congress shall make no law respecting an establishment of religion, which has been interpreted to require a rigid wall of separation between religious expression and the government at all levels, not just the federal level, as the First Amendment actually says. Although a court ruling of unconstitutionality does have the merit of placing the supposedly violated constitutional principle beyond the reach of politics and public opinion and therefore protects it better, that advantage is also a minus. Politics, after all, is also self-government. And in a democratic system like ours, governmental policies at least partly reflect the results of communication and compromise among affected parts of our society through our elected officials. This was among the major points in the thoughtful analysis of the American system by the political theorist Wilmore Kendall. Writing in the 1960s about the Supreme Court's recent decisions banning government-sponsored school prayer, Kendall maintained that the alternative to what he believed was the court's incorrect and dogmatic interpretation of the Establishment Clause was what he called neighborliness. His preferred position, quote, "let the people of the local community work the matter out," is the precise opposite of a Supreme Court decision which does indeed, as Robert Bork warned, leave the public helpless. As Kendall wrote, the fact that the relevant negotiations are and must be conducted face-to-face and are presided over by the necessity of living together tomorrow sets a stage on which alike neighborliness, sense of humor, and the avoidance of doctrinarism can thrive. The attitude of good faith compromise among fellow citizens of which Kendall spoke has a basis, he believed, in the leading statement of American political theory, the Federalist Papers, the famous set of 85 essays written primarily by Hamilton and Madison to urge the state's adoption of the proposed Constitution, again in 1787 and 1788. One of the most famous of these essays is Madison's number 10, in which he discussed the problem of faction, meaning here either a majority or a minority which demanded a public policy that was contrary or damaging to what he called the permanent and aggregate interests of the community, that is, the interests of the nation as a whole over the long term. To put it briefly, Madison held that a lasting majority faction would be unlikely to form, or at least to rule, because the country would be too large and diverse for one to hold together. But Kendall says, I think correctly, that the language of the Constitution, the Philadelphia Constitution, as he calls it, meaning the Constitution that came out of the convention that drafted it, without the Bill of Rights that would later be added, and, more relevantly to the point he is making here, without the interpretation of the Constitution's spirit that is provided in the Federalist Papers, does not on its own solve the majority faction problem. Admittedly, the complexity of the governmental system which the Constitution sets up makes it harder than it would be in a simpler system for the majority to impose its will on the rest of us. But if we look a second time, Kendall notes, we see that the constitutional barriers are in fact barriers only to what we may fairly call an ephemeral and therefore frivolous majority faction. If my faction has a majority out in the country, and if I can hold it together that long, I can capture a majority of the House within 2 years, a majority of the Senate plus the presidency in 4 years, and a majority of the Supreme Court so soon as either A, enough justices die off, or B, my majority faction decides to juggle the Supreme Court's appellate jurisdiction, that is, to remove certain kinds of cases from its authority, or to pack the court. The language of the Constitution leaves both options open to Congress. But these things generally haven't occurred, nor, according to Kendall, has the majority in America generally run roughshod over political minorities at the federal level. This is because the Constitution, in practice, has what he called a conservative bias that the mere text of the document does not provide, one that is, as Kendall writes, dictated by obvious considerations of prudence. Conservative bias here means a bias toward going slow and toward inaction more than action. According to Kendall, something therefore needed to be added to the Constitution in order to create what he regarded as this healthy conservative bias. Publius, he writes, referring to the pen name used by the authors of the Federalist Papers, takes a dim view of legislation that goes on the books with the support or acquiescence of the bare majority. One might say that the ultimate addressee of his plea for government by consensus is the majority, popular or legislative, and that what he calls upon it to do is to bide its time, even after winning, until it has behind it a genuine consensus. He does not wish to see the new central government go into the business of imposing new legislation that on the face of it requires coercive enforcement upon any considerable number of people out in the population. For large-scale coercive enforcement of the law is itself likely to prove inconsistent with domestic tranquility. And the fact that Publius does not put it quite that way does not warrant our supposing that the thought was absent from his mind. In a debate with the famous historian and political scientist James McGregor Burns on governmental deadlock, or what we now call gridlock, Kendall said, "Our system was devised by men who feared and disliked, above all things, the operation in politics of sheer naked will. It was devised for purposes that had nothing to do with simplistic formulae, like the will of the people or government doing things for the people. It was devised to bring about amongst us a more perfect union, thus not to divide us into majority and minority, to assure us the blessings of liberty, thus not to keep us busy coercing one another. Above all, to achieve the ends of justice, thus not to effectuate the will of any group amongst us, but rather to reconcile the conflicting claims of different wills amongst us. It was devised to effectuate not the will of the people, but rather, as the Federalist puts it, the deliberate sense of the community, the whole community or society, as to what ought to be done, what policies ought to be adopted." As Kendall and his political science colleague George Carey note in their book Basic Symbols of the American Political Tradition, the Federalist Papers urge what they call a constitutional morality, a certain way of looking at it and interpreting its provisions that will make it a viable instrument for the purposes stated in the preamble, establishing justice, ensuring domestic tranquility, etc. Once accepted, they write, such a morality assumes over time something of a binding character. We tend to look upon it as a part of the very Constitution itself, one that is binding upon both office holders and citizens. Kendall stresses that the language of the Constitution doesn't actually describe the government's three branches as equal, even though Americans have long viewed them in that way. Congress could, if it wished, impeach both the president and the members of the judicial branch and use its power of the purse to attempt to subordinate the other branches to its will. Quote, "Nothing in the Constitution tells Congress to restrain itself, to use the powers at its disposal only in the most critical situations, that is, the extreme powers I've mentioned. Nothing in the Constitution does, but parts of the Federalist Papers do." The Federalist Papers, Kendall and Carey say, are much of the source for our healthy belief that the Constitution's structure generally requires a go-slow approach in legislation. The importance of such delay lies in its tendency to leave room for and facilitate compromise. It allows for what they call the emergence of a consensus among the people, a consensus that is quite different from the simple majority rule of strict or pure or direct democracy. Quote, "Delay provides the opportunity for give and take, wherein binding decisions are taken only after opinions are allowed to settle on the available alternatives, and this only after due account has been made for the arguments pro and con with an eye to the sentiments, feelings, and probable reaction of those whose cooperation is essential for the successful implementation of the policy or program under discussion." Publius, Kendall and Carey maintained, must have something very akin to consensual politics in mind, given his clear opposition to a merely plebiscitary or will of the people, do it now system, and given also his emphasis upon the advantages and virtues associated with an extended republic, meaning a large and diverse republic. The Constitution's structure does tend to mean delay in legislating, but, they write, delay and deliberation do not inherently prevent rule by factions, either majority or minority. Publius's belief that these factors would serve to block factious majorities is clearly based on two related assumptions which are not articulated in Federalist 10, but which are nevertheless there and serve to give meaning to the Federalist. One, the American people are assumed to have a sense of right and wrong, a feeling for justice and doing that which promotes the true interests of the community. Two, if given sufficient opportunity, which involves time to deliberate and meditate, the vast majority of the American people will opt for that which is just and designed to promote the permanent and aggregate interests of the community, rejecting the appeals of factions. Publius's teachings also, quote, clearly urge a cooperation among the branches. There must be, quote, a healthy sense of self-restraint in them. Otherwise, Kendall and Carey continue, in a war of all against all among our branches, we can well imagine any number of conflicts that might occur to bring our system to the very brink of a total breakdown. To explain this interpretation of the Federalist Papers a bit further, for most purposes, Kendall and Carey write, we in America do not live under the Philadelphia Constitution, but under what we may term the Federalist Papers Constitution. The Federalist Papers, which we are in the habit of reading wrongly as an explication of the Constitution, in fact give us a new and different Constitution, or if you like, a special set of rules for operating the Philadelphia Constitution, or that is the bare text, which most of us have taken to heart. Special rules which most of us, they say, have taken to heart, adopted in our hearts as our very own, and which in fact govern our political life almost as completely as if they were in fact our Constitution. Similarly, Kendall explains in one of his essays that, quote, we have never, for purposes of effectuating drastic legal changes in this country, governed ourselves according to the Philadelphia Constitution, but rather according to an unwritten Constitution whose major effects have been A, to repeal what might be called the plebiscitary potential of the Philadelphia Constitution, mainly by B, outlawing, in effect outlawing, the weapons with which the Congress could easily have turned it into a straight congressional supremacy constitution. The idea that we have three separate and coordinate branches, according to Kendall, comes to us not from the Constitution, which is, in his view, a legislative supremacy constitution, but from the Federalist, which lays down for us a constitutional morality, a political ethos that is, as Kendall said, as natural to us as the air we breathe. Congress does not forget that it possesses the ultimate weapons. It simply believes, as the Federalist teaches it to believe, that it ought not to use them, that it ought to treat the other two branches as equal and coordinate. Similarly, the other branches must not throw their weight around either. Again, that's Kendall's phrase. The Federalist instructs us, as a matter not of constitutional law, but of constitutional morality, that none of the three branches shall force a showdown with the other branches. Nor is there anything more remarkable in our history as a nation than this. There never has been a showdown, despite the fact that the Philadelphia Constitution from beginning to end simply invites a showdown. And according to Kendall, our political system obviously cannot survive adamant showdowns between branches. The system, as modified by the constitutional morality taught in the Federalist Papers, Kendall says, requires of us that we learn the virtue of patience, along with the virtue of accepting, and accepting with good grace, political defeat. And we should begin to understand why the system has room for institutions that seem to force us into such a morality, even though by all outward evidences they also seem to thwart the will of mere majorities within our society. The other concept related to constitutionalism that I'd like to discuss in this lecture comes from perhaps a surprising source. The Harvard literature professor Irving Babbitt, who lived from 1865 to 1933, who wrote mostly about modern literature, about the dangerous influence he believed the philosopher Jean-Jacques Rousseau and his followers in modern politics and elsewhere had exerted on Western culture, and about a variety of false paths, as Babbitt saw them, that were closely related to Rousseau in higher education. Babbitt was an inspiration to and a leader of the New Humanists, a small group of scholars and writers in the early decades of the 20th century who believed not in atheism or man's self-government independent of God, like their humanist contemporary John Dewey and his followers, but in the very different principle that the essence of man lies in his spiritual superiority over nature, including the lower parts of human nature. They believed the human race's moral, religious, intellectual, and creative capacities were thus more important than the continual pursuit of self-interest and material gain. Man should, according to the New Humanists, not only cultivate such capacities to the greatest extent he can, but also take guidance from them to the greatest possible extent. These disciplinary arts, in the words of their eminent successor Russell Kirk, which, quote, teach man to put checks upon his will and his appetite, are provided to us by, quote, the higher reason, which grows out of a respect for the wisdom of our ancestors, and out of the endeavor to apprehend order in the person and order in the republic. The connection between such core beliefs and at least a partial philosophy of politics was indicated by Babbitt as early as his first book, Literature and the American College, published in 1908. In one sense, he wrote, the purpose of the college is not to encourage the democratic spirit, but on the contrary, to check the drift toward a pure democracy. If our definition of humanism has any value, what is needed is not democracy alone, nor, again, an unmixed aristocracy, but a blending of the two, an aristocratic and selective democracy. Babbitt explained that he had in mind, quote, the selective democracy of the sober second thought, not the democracy of the passing impression. He endorsed what he identified as Abraham Lincoln's understanding of true democracy, according to which, as Babbitt put it, the good sense of the whole people tends to triumph in the long run. In a footnote to this last comment, he identified the Senate, the Supreme Court, and the Constitution as the three institutions, quote, especially intended to embody the more permanent judgments and experience of democracy and at the same time serve as a bulwark against popular impulse. Babbitt offered a not very popular critique of American culture and of modern democratic man. It was not primarily a warning against demagoguery or crude politicians, although he disliked those things, but really a warning about ourselves. His last major work, Democracy and Leadership, published in 1924, stresses dangerous social trends and errant ways of thinking about public affairs, more than his strong opposition, also expressed there, to the most ambitious and vigorous presidents of his lifetime, Theodore Roosevelt and Woodrow Wilson. Their popularity and even their personalities and messages, Babbitt seems to say, were natural outgrowths of a culture gone awry. He presumably didn't want to see any more presidents like them. But his greater concern in Democracy and Leadership was getting Americans to think differently, if possible, about political issues and government. It might be said that Irving Babbitt's essential conviction or insight concerning politics was that good character in the people, good citizenship, reasonable thinking about public issues, the selection of good public office holders, and the framing and execution of good public policy were simply inseparable from one another. Accordingly, he saw public life as fundamentally a matter of the conscience and the soul. The unit to which all things must finally be referred in political analysis, Babbitt writes in Democracy and Leadership, is not the state or humanity or any other abstraction, but the man of character. Compared with this ultimate human reality, every other reality is only a shadow in the mist. Democracy and Leadership warned that America, even in the early 20th century progressive era in the 1920s, before the federal government's enormous growth in the New Deal period, let alone later trends, seemed to have taken a decisively wrong political path. The timing of Babbitt's lament is noteworthy. Conservatives and libertarians alike, of whatever stripe, tend to view America's greatest wrong turns, as they see them, as occurring in the 1930s at the earliest, or the 1960s at the latest. Democracy in Leadership, however, argues that things are already badly wrong in the Coolidge years. Of course, many people on today's political right have long attacked the progressive movement and its leading spirits, including Wilson and Theodore Roosevelt, but their sense of what went wrong in early 20th century America arises from trends that occurred in politics, government, and the intellectual realm. Babbitt, in contrast, worried at least equally about the country in a deeper sense, stressing the quite different question of what, in his judgment, Americans were becoming. He feared that they were no longer good citizens because they and their public leaders were growing less civilized. In order to understand the basis for Babbitt's striking claim about the state of American political life, it is essential to grasp a great dichotomy he saw in our history. In speaking of modern civilization more generally, Babbitt, the literary scholar, distinguished between what he called classicism, which for him is good, and romanticism, which he regarded as bad. In discussing America's public life and politics in Democracy and Leadership, his rough equivalents of these terms are what he called unionism and Jeffersonianism. The Jeffersonian liberal, Babbitt explained, has faith in the goodness of the natural man, and so tends to overlook the need of a veto power, either in the individual or in the state. In contrast, what he called the unionist tradition, exemplified for Babbitt by George Washington and Lincoln, asserted that the state should have, like the individual, a, quote, higher or permanent self that greatly restricts its, quote, ordinary self. The state's higher self should be embodied in institutions that set bounds to the popular will. For Babbitt, this duality between the higher and the lower public self corresponded to the distinction, quote, between a constitutional and a direct democracy, end quote. Thus, a good democracy and a bad democracy. Babbitt's third and equally central concept in his analysis of American politics is what he called imperialism. Although highly critical of the country's recent geopolitical expansionism and also of President Wilson's post-World War I ambitions for vast reforms in Europe and in international affairs, his use of the term imperialism signifies far more. It means briefly the craving to impose things on others or on one's society, to change either of these in accordance with one's own will. Its opposite was the citizen or leader who subordinated himself to high principles of conduct. No amount of devotion to society and its supposed interests, Babbitt insisted, can take the place of this inner obeisance of the spirit to standards. It was apparently his belief that good government and policy were impossible, at least for long, without an overriding sense of humility. Nothing, he writes, will avail short of humility. Humility, as Burke saw, is the ultimate root of the justice that should prevail in the secular order. It may help to provide two examples here. The first is Theodore Roosevelt. What we feel at the very center in Roosevelt, Babbitt remarked, is the dynamic rush of an imperialistic personality. What we feel at the very center of Lincoln, on the other hand, is an element of judicial control, and in close relation to this control, a profound conception of the role of the courts in maintaining free institutions. Babbitt worried about recent presidents' expansions and advocacies of presidential power, along with Wilson's claim as a candidate in 1912 that presidential election winners, as the only nationally elected officeholders, were the true representatives of the people, meaning that Congress wasn't. Babbitt also foresaw a possible scenario in which, quote, a predominant element in our population, having grown more and more impatient of the ballot box and representative government, of constitutional limitations and judicial control, will display a growing eagerness for direct action. This is the propitious moment for the imperialistic leader, end quote. Babbitt's thinking on good and bad democratic citizenship has been employed to some degree in a work by one of his most prominent admirers in our time, the conservative political theory scholar Claus Rinn. The Survival of Constitutional Democracy, Rinn wrote in the late 1970s in his book Democracy and the Ethical Life, requires citizens with a, quote, constitutional personality. Citizens with much self-restraint, willingness to compromise, and tolerance of disagreement. Dispositions that do not, however, extend to acceptance of the ignoble or exclude readiness to combat positive evil. Above all, the constitutional personality is sensitive to the needs of the common good and has the integrity and strength of will to press this higher purpose. This is much like Kendall and Carey's Publius in the Federalist Papers, and much like the true and healthy constitutional spirit they believed, more than Irving Babbitt, that the American people and government had long maintained. Perhaps the constitutional and political morality taught by Publius in the Federalist Papers and by Irving Babbitt is the best basis for responsible government if the Supreme Court ever becomes more restrained about declaring enactments by our elected branches unconstitutional. I hope this lecture has provided some food for thought about our Constitution and our red-blue divide. Thank you.